UK Home Office breaking decision after government's rule change. Immigrants react. The letter arrived on a Tuesday morning. No warning, no phone call, no preparation, just a Home Office envelope, white, official, cold, sitting on a doormat in a terraced house in Birmingham, carrying words that would change everything. A rule change that immigration lawyers had flagged with alarm, that community groups had protested for weeks, and that the government had quietly signed into effect, had just made contact with a real life. A sudden knock on a neighbor's door. A bright light through frosted glass. A border force officer asking questions that sounded administrative, but weren't. This situation didn't unfold over months of courtroom drama. It unfolded in 72 hours. 72 hours that could end a decade of lawful residence. 72 hours that could separate a parent from their British-born children. 72 hours that could destroy a life built piece by piece, document by document, renewal by renewal. One wrong move here, one missed form, one unchecked box, one outdated piece of evidence, and you could be on a flight out of Heathrow tomorrow. What the Home Office did crossed a line that immigrant communities across the United Kingdom had hoped would hold, and when that line broke, legal advocates did not hesitate. They responded with speed, with coordinated pressure, and with a level of organized resistance that shocked even seasoned immigration professionals. Most people panic in this moment. They make the same mistake. They fall straight into the trap. But today, you're going to do something different. For several months now, there had been signals. Not from official press conferences, not from published policy documents, just signals that the Home Office was preparing something unusually sweeping. The government had been vocal about border reform, yes, but also methodical in that approach. Their moves followed a pattern, a rhythm, almost a script: announce, consult, delay, then quietly implement. But what triggered alarm among immigration practitioners this time was that the consultation process suddenly went silent. The usual government channels dried up. The typical stakeholder briefings stopped appearing on calendars. And then, nothing. Immigration lawyers who monitor policy shifts recognize the indicators. The removal of previously scheduled public engagement sessions. The sudden appearance of internal Home Office memos referencing accelerated implementation timelines. The consolidation of several previously separate rule amendments into a single omnibus change. The sudden disappearance of the usual pre-announcement leaks to sympathetic journalists. And when the Home Office goes quiet like that, something loud is coming. Earlier this week, legal observers and immigration news services detected what they described as a significant structural shift in UK visa and settlement policy, including enforcement language not seen in the immigration rules for over a decade. These are moves the Home Office only makes when signaling something specific: a tightening of the evidential requirements that applicants must meet, a narrowing of the discretionary powers that caseworkers previously used to benefit applicants in borderline situations, or a fundamental recalibration of what continuous lawful residence actually means for settlement and citizenship applications. Observers weren't sure which one applied in its full scope, or whether all three were operating simultaneously. But one thing was unmistakably clear: the Home Office was changing its posture, shifting from processing to enforcement, from accommodation to pressure. And when that happens without transparent public explanation, the people most at risk are the ones who aren't watching closely enough. The decision issued by the Home Office this week was not routine, it was not symbolic, it was structural. And for tens of thousands of migrants currently in the system, it carried immediate practical consequences. Immigration solicitor after immigration solicitor, in statement after statement, described the move as sweeping in its ambition, dangerous in its speed of implementation, and most importantly, deliberately difficult to challenge because of how it was framed within the existing rules, rather than as a standalone legislative change. That framing matters enormously, because when a change is buried inside the existing immigration rules, rather than introduced as primary legislation, parliamentary scrutiny is limited. The government can move fast, and the people affected are often the last to know. But strategy only works if the other side hesitates. Immigration legal advocates did not. Their response was among the most coordinated resistance movements seen in UK immigration civil society in recent years. Today, multiple verified legal sources confirmed that advocacy groups and pro bono immigration chambers launched a coordinated challenge targeting the implementation of the new rules, including a judicial review application targeting a specific provision that had recently been modified for what analysts believe was the purpose of reducing successful settlement applications without formally changing the eligibility threshold on paper. They acted before the Home Office could fully bed in the new guidance. They targeted the evidential standard changes affecting long residence applications. They targeted the new financial requirement thresholds affecting family visa holders. They targeted the reinterpretation of absences abroad connected to continuous residence calculations, a change that could retrospectively affect people who traveled for family emergencies, medical treatment, or bereavement during the COVID period. This wasn't symbolic resistance, it was legally actionable. And that's what made the original Home Office announcement so alarming in the first place. Let me break down what has actually changed and why it matters to you, specifically, depending on where you are in the immigration system right now. The first major shift involves the evidential requirements for long residence applications, specifically the 10-year route to indefinite leave to remain. Previously, caseworkers had a degree of discretion when assessing whether absences from the UK during that 10-year period were reasonable or exceptional. That discretion has now been significantly narrowed. The new guidance instructs caseworkers to apply a more rigid interpretation of what counts as an acceptable absence. If you took trips home to visit elderly parents, if you were stranded abroad during a pandemic travel disruption, if you went back for a wedding or a funeral, those absences may now be counted against you in ways they were not before. The second major shift involves financial thresholds for family visas, most significantly the spouse and partner visa route. The minimum income requirement for sponsoring a partner from overseas was already raised significantly earlier this year, but the new rule change adds a layer of complexity on top of that threshold. It now requires that the income evidence submitted must meet a stricter definition of reliable and ongoing earnings, meaning that people who are self-employed, on 0-hours contracts, or who recently changed jobs may find their applications refused even if their headline income technically meets the number. This is not a small technical adjustment. This is a deliberate tightening designed to catch more people at the documentation stage rather than the eligibility stage. The third major shift affects students, specifically those on graduate visas or those transitioning from a student visa to a skilled worker visa. The Home Office has introduced new guidance that affects how time spent in the UK on a student visa is counted toward long-term residence routes. In practical terms, this could extend the amount of time some migrants must remain in the UK before becoming eligible to apply for settlement, not because the rules say so explicitly, but because of how the calculation now works in practice. Immigration advisors are warning that this change is the one most likely to surprise people who thought they had a clear timeline mapped out. Now let's talk about what immigrant communities across the UK are actually saying in the wake of this announcement. The reaction has not been quiet. In London, Manchester, Birmingham, Leicester, and online, across WhatsApp groups, Facebook communities, and migrant support forums, people are asking the same questions with increasing urgency. Does this affect my renewal? Does this affect my settlement application that's already submitted? Does this affect my children? And the honest answer, the answer that immigration lawyers are giving, is it depends. And that it depends is precisely what makes this moment so dangerous. One of the most important things to understand about UK immigration rule changes is that they do not always apply prospectively. Sometimes a change takes effect immediately and applies to applications already in the queue. Sometimes the Home Office issues transitional provisions that protect people who applied before a certain date. And sometimes, and this is the dangerous scenario, the guidance changes in a way that affects how previously submitted applications are assessed, even though the formal rules technically haven't changed. Right now, based on the current guidance, legal observers believe that applications already submitted before the change date may still be assessed under the old evidential standards. But that is not guaranteed, and the window to get clarity is narrow. If you have a live application currently sitting with the Home Office, the most important thing you can do right now is contact a regulated immigration advisor or solicitor and ask them to review your case file against the new guidance. Do not assume that because you submitted before the change date, you are protected. Do not assume that your application is processing normally just because you haven't received a decision. And do not, under any circumstances, respond to any Home Office communication without getting professional advice first. The stakes are too high for assumptions. There is also a specific group of people who need to pay attention to this update, even if they are not currently in the middle of an application. If you are on a visa that is due for renewal in the next 6 to 12 months, the new rules will almost certainly apply to your renewal application. If you are planning to apply for ILR, indefinite leave to remain, in the next 12 months, you need to recalculate your qualifying residence period under the new absence guidance before you set a target date. If you are sponsoring a family member from overseas and your income is based on self-employment or variable hours, you need to reassemble your financial evidence package immediately with the new standard in mind. I want to address something directly because I know some people watching this are already feeling a familiar wave of anxiety. That anxiety is legitimate. It is not irrational. It is the appropriate response to a system that changes its rules frequently, gives limited notice, and places the burden of compliance entirely on the individual. But anxiety without action is not useful, and the most powerful thing you can do with the anxiety you feel right now is convert it into preparation. The Home Office has a track record in recent years of implementing changes that are technically lawful but operationally harsh. The hostile environment policies, the Windrush scandal, the repeated increases to the financial thresholds for family visas. Each of these happened through the same mechanism, incremental rule changes that accumulated into life-altering consequences for people who were not watching closely enough. The lesson of each of those moments is the same. Information is protection. Knowing the rules, the real rules, not the simplified version, is the difference between a successful application and a refused one. Here is what I need you to take away from this video before you do anything else. First, if you are affected by any of the 3 rule changes I described, write it down. Long residence calculation, family visa income evidence standard, or student-to-worker transition timelines. Second, verify your current visa expiry date and your target application date against the new guidance. Third, if you are within 12 months of any major application, consult a regulated legal professional, not a Facebook group, not a community volunteer, a regulated solicitor or advisor who is accountable for the advice they give you. Fourth, document everything. Every day you are physically present in the UK. Every piece of employment evidence, every bank statement, every letter from an employer or landlord. The Home Office does not give the benefit of the doubt. You have to give it to yourself by building a case so airtight that refusal becomes difficult to justify. As the political situation continues to evolve, more details will emerge about what the government hoped to achieve with this particular package of changes. Some analysts believe it is designed to reduce net migration numbers without formally restricting any specific visa category, a way to achieve political targets through procedural tightening rather than headline policy. Others believe it is a precursor to larger legislative changes that will be introduced later in the parliamentary session. Either way, the direction of travel is clear. The system is getting harder. The margin for error is getting smaller, and the people who survive it, who protect their status, their families, and their future in this country will be the ones who stayed informed, stayed prepared, and refused to be caught off guard. Knowing this doesn't make you a troublemaker. It makes you smart. It means you are prepared. It means you are protecting your family. Share this video with everyone in your community who is navigating the UK immigration system right now. It might make the difference between a successful application and a life turned upside down. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.